Well, before we can look at what courts do, we have to figure out what the courts are. So let's take a look at that first. The court's job basically is to interpret and apply laws that a legislature would make. So they'll look at a specific controversy that's brought before them and they will decide based on the law how that decision could be made for either party. It resolves disputes between companies and government and individual people. Its job is to kind of check and balance. So it upholds the limitations of government. It protects us against abuses by the different branches of government. It's supposed to protect basically the minority from the majority, so the rights of people who can't protect themselves. And this idea of equal treatment and fair play, the courts are open to all. The law is supposed to be blind. That's why you'll often see a representation of law with a blindfold on and with scales, that justice is equal and it's applied without any judgment being based on it. Now, we have two main different types of courts. One are the trial courts, one are the appellate courts. The trial courts are fact-finding courts. This is where most cases will begin. There's juries and judges. These are the ones that you see on Law and Order. And they consider fact of what happened, and the law is what's going to happen now that this has happened. Now, the appellate courts in general are law reviewing courts. They're not looking for new factual testimony. Really, they're determining whether the law has been applied properly. And they're head by judges and justices. We don't have juries in those. We have actually two different sections of law in our country. One is at the state level, one is at the federal level. The state level is the one that's going to touch you the most if you're going to be involved in any court cases. So if you have to deal with an estate or a divorce, or you have to go to traffic court or any of those things, all of that is done at the state level. The federal courts, actually Article 3 of the Constitution established the judicial branch as one of the three branches of government. So we of course have the legislature, we have the executive branch, and we have the judicial. For the most part, it's not really making laws, it's applying and interpreting laws as they resolve disputes. And they hear a variety of cases. So here's an example of some of the cases that you might hear at a federal court. There are actually three different levels of federal court. One are the district courts. These kind of are the trial courts of the federal court system. Within the limits that Congress has set, they can hear all different federal cases. That includes civil cases and criminal cases. They also, there's the Court of Appeals, and the Court of Appeals is actually broken out by districts. So for example, here in the state of Ohio, we're in the Sixth Circuit, and that's kind of the intermediate level of appeals, because the next level would be this one, the highest court in the land, and that is the U.S. Supreme Court. This consists of a Chief Justice, and now we have 8 associate justices. We didn't always have that number. Congress is actually able to determine the number. Now, what's in a name? Well, for one thing, the Supreme Court is the only court that's mentioned in the Constitution. The Constitution says that a Supreme Court will be created, and then Congress will actually have the ability to create all the inferior courts that are deemed necessary. There's two different ways that the Supreme Court can act. One, it's original. It acts like a trial court. It's fact-finding. It gets information. So, certain cases that will come from the other branches of government will be heard in that way, cases between states. But then it'll also hear a lot of cases that are decided by lower courts, and it will determine really the constitutionality of those cases. The two ways that you can get to the Supreme Court are on a direct appeal. So if you have a right guaranteed by federal statute, like it's between two states or the government is a party to it, 90% of these cases are rejected. It's not the easiest way to get there. And then there's the writ of certiorari, and that means that you've gone through the lower court system and now you want to appeal to the Supreme Court. And you've exhausted all other legal remedies. Very small percentage get through. 7,500 requests, they only accept between 75 and 85. Now, the rule of 4 means that if 4 justices decide to take a case, then the case can go forward. And these are the kind of opinions that they might issue as justices. There'll be an opinion of the court. There'll be a majority opinion that's written. Something concurring, as you see, agrees with the verdict. We have the dissenting opinion. Plurality, where we have different opinions on why it should go through. Per curiam, they don't sign it. And then a memorandum order, which is they're going to vote, but they're not actually going to offer an opinion.